Good morning, everybody, and welcome to our February Focus event. My name is Ashley Wong. I am an attorney here at Equinox Business Law Group. It is a pleasure to be with you today. So today we are talking about the new age of data privacy in business. For the past 2 to 3 years, we've been seeing a lot of activity in the data privacy space and in the development of privacy laws and discussion and buzz and concern for consumer rights in data across the world. So just in the past 2 to 3 years, we've seen the first full year of the EU GDPR having been implemented and in place in the EU, which has also made waves here in the States for companies that collect data of EU residents. We've also seen the CCPA go into effect in January of this year, and as well as a number of other privacy laws that we'll be discussing today. And we've even got additional activity, even just in the beginning of this year, even just in the first few weeks of January, that we've seen US states creating new proposals for privacy laws, and so we're really seeing a lot of momentum there and a lot of change happening very quickly of just the legislators trying to catch up with the pace of technology, and so we're going to get into that today. Okay, so first, just a little bit of housekeeping. Just as a quick disclaimer, this is a presentation that is for educational purposes only. This is not intended to be providing legal advice to any of our attendees, and it does not create an attorney-client relationship. We do always recommend consulting an attorney before taking any action related to the content of this presentation or any other legal action related to your company. We will be addressing questions as time permits, and the presentation will be made available for attendees after this webinar. Okay, so what we're going to be discussing today, we're going to begin by framing our conversation, what we mean by the use of the term data privacy, information privacy, and other related terms that can be used interchangeably often. So we also have terms such as cybersecurity and information security. So we just want to make sure we're getting on the same page about what data privacy is, what it means, and then we'll understand what kinds of information we're talking about, what kinds of information and data are covered by the privacy frameworks that we'll be discussing today. We will then get into sort of the meat of the conversation, probably why you all are here, an overview of the privacy laws that currently exist and those that are in process or in early stages of implementation. And then finally, those that are coming sort of down the pike of the legislative process and what we need to be aware of there, especially here in the state of Washington. Finally, I'll provide some practical advice of what this means for you and your business and what your next steps will be. Okay, so beginning, we're going to frame our conversation of what is data privacy. So data privacy, there are two concepts that I want to distinguish here. Varying terminology is used, so I just kind of want to clear the landscape of what we're talking about. So data privacy and information privacy, those terms are often used interchangeably just to address different kinds of data and the different media that they can be stored on. Versus data security, cyber security, data protection, those sorts of terms. So when we are talking about the concept of data privacy, what we're really talking about is an interactive, holistic, business-focused program around the management, use, and governance of data. So we're looking at who is authorized to collect data, access it, use it, share it, and for what purposes, and with whom can it be shared, which third parties can information be shared with. And so it's a much more than just a technical exercise of securing data. It's really how are we managing all of the information with which we are being entrusted as a company. Data security, however, is concerned with sort of shoring up your systems to prevent unauthorized access of data, both from internal sources and from external sources. And it is an important and critical part of a privacy program, but it is a subset and just a piece of your privacy program that you should be putting in place if you are handling data on a regular basis. Okay, so this is just an illustration of, with respect to the data that we are talking about here today, what it means to have a full comprehensive privacy program, and then what the sort of security piece of that looks like. So if you are looking at security, you're going to be looking at mostly technical measures that you're putting in place, although there are operational measures that you should be putting in place as well to ensure security, like phishing training, for instance. But you'll also be looking at things like password management, multi-factor authentication, vulnerability scanning, penetration testing, incident response. A privacy program is going to be much more comprehensive, and it's going to include a lot of things that aren't related to security, including obtaining consumer consents in compliance with applicable laws. So that might be an opt-in or an opt-out, depending on which laws apply to you. It will also include your contracts, so ensuring that you have data protection agreements in place when they're required to be in place or when it would be legally advisable to do so, updating your privacy policy, consumer rights to access and deletion. What we're seeing now is just a major trend is putting the control in the hands of the consumers with respect to what data is being collected about them. Okay, so what kinds of data are covered by the data privacy laws that we're talking about today? So again, this is getting on the same page of what do we mean when we say data or information. And again, varying terminologies are used here. So we see a lot of information, a lot of different terminologies such as personal information, personal data, PII, personally identifiable information, and these terms are often used interchangeably. When we're talking about the legal frameworks, we also see varying terminology being used even in the laws that are coming down and being put into place today. We're seeing different terminology that's used in the CCPA, for instance, than was used in the GDPR, and those terms also have different definitions. So we want to make sure that we understand what we mean when we are looking at the definition of personal data. There are also other categories of information that are heightened categories or more critical categories of information, such as sensitive personal information, protected health information. You might also see financial information, information that addresses belonging to a protected class. So those sorts of things are all going to require higher standards for protection. And so we want to be aware when laws also have specific requirements around sensitive personal information or other things of that nature. So before I move on to the next slide, I just want to give a bit of a disclaimer. You will likely not be able to read what's on the next slide. I don't typically like to include very, very dense text on any slide, and I don't expect anybody to read all this, and we're not going to go through all of it today, but we'll be distributing this presentation after the fact, and so I just wanted to note that it's intended as a reference page for you, and it's just an illustration of the different types of data that are specifically listed in the California Consumer Privacy Act, which is really what is sort of the hot topic of conversation right now since it's in the process of implementation. And really gives a good picture of what kinds of information that we're concerned with when we're talking about data and data privacy. All right, so here's the slide. So just to kind of hit on just a few of the major areas here, when we're talking about data, we are looking at things such as identifiers. This is probably what you're used to seeing, so names, address, email address, account numbers. So those sorts of things that probably most companies are going to be collecting in some form or fashion. Customer records, so if you sell information, if you sell products or services, you may be collecting or compiling customer records. Characteristics of protected classifications, I noted this. These are actually treated differently under certain laws and require heightened levels of protection. Commercial information, biometric information, geolocation data is one that is often being collected through the use of cookies, and so that can get kind of lost if you are not highly technical and really understanding what your cookies are collecting. Education information, and then finally, this is an interesting one because it hasn't really been seen before, but inferences that are drawn from any of the information that is identified in the previous categories, and that information then being used to create a profile about the consumer reflecting their preferences or characteristics. This is pretty common in marketing and advertising areas, and so that being considered personal information is a unique aspect of the CCPA. Okay. So with respect to your company, what this probably means for you, I just wanted to break it down into sort of simpler categories. We're going to be looking at most likely consumer information and employee information. And I just wanted to highlight this because we often think about information that we're collecting through our websites as the information that is pertaining to these data privacy laws, but we may also be looking at employee information as also being covered here because it is included in some of the more recent updates to the CCPA. Consumer information, so again, names, email addresses, phone numbers, order details, credit card information, information that's collected through cookies, your IP address, and other unique identifiers. And then employee information is just any information that you're collecting from your employees as an employer that could be used to identify them. And what we do see a lot of is health information that employers don't realize that they're collecting health information, but they may be, for instance, to comply with ADA requests from their employees, to process sick leave, FMLA, or if you conduct any drug testing. And so there are rules, specific rules around sort of how you're storing that information and maintaining that confidentiality there. Okay, so now let's get into the actual privacy legislation that is why you guys are all here today. So to start off, we're first going to quickly touch on privacy laws in the EU. So these really paved the initial landscape of privacy legislation and also impact many US companies even when you don't have a physical presence in the EU. If you are collecting data of residents in the EU or otherwise directing your activities towards the EU, even if you don't have a physical presence there, it could impact you. And then we're going to bring it back home to the US, and we will briefly touch on privacy laws that have existed for years and are well-established law, but we do not have a comprehensive federal privacy law here in the United States that addresses sort of all data being collected about consumers. So what we are seeing is the states taking matters into their own hands, particularly California is what most folks are concerned about now. But the states are kind of working it out, figuring it out, and so we're going to talk about a number of those state laws as well. We do also have legislation in process here in the state of Washington that is moving very quickly this year. It's been a few years that they have been trying to put in place some legislation here in Washington, and it narrowly failed last year, and it's got a lot of momentum this year. In 2020 alone, we've seen privacy laws proposed in a number of states, including Massachusetts, Virginia, Florida, New Hampshire, Illinois, Nebraska, and like I said, Washington. So it's going to the House for consideration here in Washington. That has been already overwhelmingly approved by the Senate, and so we should know by April whether the Washington Privacy Act is going to be passed. Okay, so first off, we're going to start with the GDPR purely because it was first in time here as far as sort of these comprehensive privacy legislations that we are starting to see in the recent years. So the GDPR went into place in May 25th of 2018, and it really created a worldwide tsunami and a data privacy discussion, and it fundamentally changed how many businesses handle and think about personal information. It really puts the control into the hands of the consumers of EU residents as to how their information is collected and what rights they have in that information. So again, the purpose is to enhance the data protection rights of individuals. And the other piece here, and this is just sort of a nuance of EU law, so what existed before the GDPR was a directive, and a directive, it says these are, says to all of the EU states that these are the expectations as far as the end state of what that legislation needs to look like in your country, but ultimately the different states have freedom as to how that implementation happens. Regulation, on the other hand, which is what we have in the GDPR, says that it creates a unifying regulation for all states that they all have to comply with, and so it just sort of brings the international business landscape together in that sense. So who is covered by the GDPR? It's going to be controllers and processors of personal data of individuals in the EU. You do not have to be located in the EU, like I said. Processors are going to be often service providers, so anyone with whom the controllers are going to be sharing personal data. A controller is essentially a company who collects the data directly from the consumer for all intents and purposes. Maybe a bit of an oversimplification. So covered information, personal data is defined fairly broadly in the GDPR. It's defined as any information relating to an identified or identifiable natural person. There are certain identifiers that are specifically named, including the individual's name, identification number, location data, online identifiers, factors specific to physical, physiological, genetic, mental, economic, cultural, or the social identity of a person. So those are all classified as covered information, but ultimately is a fairly broad definition. Okay, so the basic principle of the GDPR is that companies that collect information of EU residents need to put in place a reasonable level of protection for personal data using appropriate technical or organizational measures in doing so. And what's interesting here is it does not define what reasonable level of protection is, because it's going to vary so dramatically from company to company and entity to entity regarding which data is being collected and what it's being used for. And then it ultimately puts the control in the hands of the consumers. So consumers have certain rights in the GDPR, including the right to be informed, the right to access their personal information, the right to sort of modify it or correct it if they believe that it's incorrect. The right to erasure or the right to be forgotten is the right to delete personal information. And they can restrict the purposes or the amount of information that is being processed or object to the processing of their data or certain types of uses of personal data. The penalties are very high and really prohibitive here. So it's really critical, and they're really going after sort of enforcement as well as prevention of non-compliance here. So the penalties are up to 20 million euros or up to 4% of global turnover total revenue of the preceding fiscal year, whichever is higher. So really stiff penalties. Now, the enforcement authorities do engage in sort of settlement discussions, and it's not sort of a one strike you're out type of deal, but they will be much less forgiving when imposing penalties in the event of sort of more egregious violations, such as willful or intentional violations versus simply we just didn't know we were supposed to do that type of thing. But companies really do have an obligation to do their due diligence and determine how the GDPR really does impact their operations. So now the other interesting thing that the GDPR requires is that you have to have a legitimate purpose for collecting information. And you have a duty to minimize collection so that it doesn't go beyond those legitimate purposes. And if you no longer need data for those legitimate purposes, that it is deleted. So we're really working towards data minimization here, rather than sort of the trend, especially here in the United States, is to get as much data as you possibly can and use it if you need it, have it if you need it. And so that's sort of what they're fighting against. Finally, you have an additional duty to avoid secondary uses. So if you have collected information and the disclosure of the purpose that the information was being collected for, that you then can't go and use it for another purpose, for an additional or secondary purpose, without obtaining consent from the consumer to use it for that purpose. Finally, the GDPR has a very I guess just sort of comprehensive requirement for performing data protection impact assessments under certain circumstances. So for instance, if you are using new technologies, technologies that are new to your company, and you're tracking people's location or behaviors, or you're processing personal data related to membership in a certain protected class, or using it to make automated decisions that could have a legal or other significant effect about a person, or if you're processing children's data, you have to do a data protection impact assessment. And what that means is you have to perform an assessment of what the operations are, what data you're collecting, how you're using it, the risks to that data, and in the event that it was ever breached, and then the necessity of actually processing the data that you are collecting. So that it really just highlights the need for a comprehensive privacy program. And it's going to be more than just the initial need to get compliant with the GDPR. It's not, okay, now we're compliant, we're done. It's more so, let's get our processes in place and then continue those compliance processes for the duration of the existence of the company, or for the duration of collecting that data. Okay, so what you must do. So the GDPR has a requirement that under certain circumstances, if you're processing sensitive personal data on a large scale, for instance, you do have to identify a data protection officer. There are certain requirements around who that person is and who they can be and what qualifications that they have. You do need to create a data map. And this is going to be, I'm going to sound a bit like a broken record here. This is a really critical piece of really any privacy program, whether you are complying with the GDPR, the CCPA, or any other state law that's coming down right now, that you need to understand where your data is coming from and how you're using it and how you're storing it, who it's being shared with. So understanding what data you have and how you're using it is a really critical piece of the process. And then you need to create and refine a process for performing a data protection impact assessment, because that's something that you would really need to be doing on an ongoing basis, depending on sort of the operations and changes that you make in your systems. You do need to update your privacy policy. I'm sure that you all have seen a whole bunch of, we've updated our privacy policies probably back when the GDPR was going into place back in 2018, and then also in late 2019, early 2020 with the CCPA, seeing updates to privacy policies flooding your inbox. And then you also need to make website changes. The GDPR does require opt-in consents as well as disclosures of cookie usage. So those are sort of technical changes that need to happen. Finally, you need to train your employees. Most of the time, issues that are happening with data protection and breaches are often the result of employees making mistakes and operational failure to oversee your employees and failure to ensure that your employees really understand what the company's obligations are. So you want to train your employees and make sure that they really understand what their role is, because everybody does have a role in the protection of data. And then finally, you want to consider any impacts to contracts. Now, you may have data protection agreements in place with certain vendors that do discuss what you have to do as a processor or as a controller of data, and those contracts are going to have certain required clauses, but you may also have contracts that have additional requirements. For instance, if you contract with Microsoft, Microsoft requires compliance with the GDPR for both personal information under Microsoft's definition, as well as for Microsoft confidential information. You're going to have some additional requirements there. So you do want to make sure that you understand exactly what your contracts say, and make sure that you have an attorney review those contracts before you sign them, so that you're not sort of getting yourself into heightened requirements or taking on additional risk that you don't need to be taking on when you are signing contracts. Okay, and then finally, I want to touch briefly on the EU-US Privacy Shield. Now, the reason for this is that there's a lot of misconceptions among US companies around what it is and what it means. So the Privacy Shield is not a federal US privacy law. What it is the GDPR imposes certain restrictions on exporting personal data to other countries, including in the US. So if you have servers in the United States, for instance, and you are storing information of EU citizens on those servers in the United States, you are transferring information across borders essentially to the US. So in order to transfer that data, it has to be done by approved means, and a couple of the more popular approved means are through Privacy Shield certification or through the use of EU model contractual clauses, so putting in place contracts between the controller and the processor, or just depending on sort of the nature of the transfer. So what Privacy Shield certification means, what exactly is it? It is a self-certification that allows companies to meet EU requirements to transfer personal data to the US. It does require ongoing compliance and reporting requirements, and you know, it's not without risk. I do want to mention that. So self-certification here is not without risk. The FTC can impose civil penalties of up to $40,000 per violation or per day for continuing violations if you misrepresent in your self-certification for the Privacy Shield. I want to be very clear that what it does not mean, and what the misconception that I frequently hear, is that I'm GDPR compliant because I self-certified to the Privacy Shield. That is just not the case. It's really just a mechanism to allow for the transfer of data. And so the Privacy Shield certification does not mean that you or your vendor or whoever is certified is GDPR compliant. All right, so getting into the USA, bringing it back home. We're going to first touch on existing US privacy laws before we get into any new legislation. So you may, as a company, be required to comply with certain existing privacy laws that are well established that govern different types of information. So for instance, COPPA is the Children Online Privacy Protection Act, and it governs the collection of information from children under the age of 13. HIPAA applies to HIPAA healthcare covered entities, and it governs the collection of protected health information. The Gramm-Leach-Bliley Act governs the collection of consumer financial information by financial institutions, and then there are a number of other rules, especially email marketing regulations, that I would say are sort of data privacy adjacent, that do require certain consents from consumers. In the US, we are an opt-out country, but in other countries, for instance, Canada, you do require opt-in in order to send email marketing. And then data breach notification laws, which we will touch on towards the end of the presentation today. And just as a side note, if you are a HIPAA covered entity or a HIPAA business associate, the annual breach reporting is due by the end of this month. So it's just a quick little note. All right, so let's get into the CCPA. This is sort of where all of the conversation is happening right now. So if you did join our December webinar, this slide may look a little bit familiar to you. We have added some additional information based on updates that we've seen just in the last few weeks. So the CCPA went into place on January 1st of this year. The purpose of the CCPA, the California Consumer Privacy Act, is to provide consumers with information and more control over what data is being collected about them. You are covered by the CCPA if you are a for-profit company that does business in California and collects personal information from consumers in California. Now, I'm just going to pause there really quick, just as a quick note. Doing business in California is a question that you'd probably want to talk to an attorney about if you are not sure. If you are selling product or services in California, then you are likely doing business in California. If you don't sell product or services in California, but you have servers there, or you contract with vendors there, or you otherwise sort of avail yourself of doing business in California, there's a number of different factors there that you'd want to look at. That's just sort of a piece that I wanted to highlight, because you don't have to necessarily be directly selling to consumers in California in order to be considered doing business there. And then, so then the second part of the test is if you either have an annual gross revenue greater than $25 million, if you buy, collect, or share the personal information of more than 50,000 consumers, households, or devices for commercial purposes, or if you collect 50% or more of your annual revenues from selling consumers' personal information. Now, the second piece of that second half of the test of collecting, sharing personal information of more than 50,000 consumers is probably where most businesses are going to fall. 50,000 sounds like a large number, but really it's easy to get there. If you have folks who are visiting your website, if you have more than 200 people visiting your website every day and you're collecting cookies, then you likely will meet that test. Covered information under the CCPA is defined very, very broadly. So I think we looked at that definition earlier, and it does include things like IP addresses if they can be sort of paired with other information, or if they otherwise identify the consumer. And it also includes browsing and search history, so online sort of collection of information, and then location data and cookie data. The California Attorney General is also still making changes to the law, and those proposed changes have have sort of been under review over the last couple of weeks. So they've recently published some changes just a couple of weeks ago. The CCPA, similar to the GDPR, provides certain rights to consumers, including the rights to notice of what information is being collected about them, the right to access that information in a way that's usable, and the right to opt out or under certain circumstances opt in to the collection of data, the right to request deletion of information subject to certain restrictions that have been clarified recently, and the right to equal services and prices whether or not they give consent to collecting their data. The penalties here. So there are two different types of penalties that companies could see for violating the CCPA, and those include civil penalties. So the Attorney General, for instance, saying coming to you and saying you're not complying with the rules, and those can be sort of the first tier is $2,500 per violation for non-intentional violations. I do want to note that that could be per record. So per violation could mean per record, which means that that number could multiply very quickly if you're collecting information of sort of tens of thousands, hundreds of thousands of individuals, or $7,500 per violation for intentional violations. Now there is a 30-day cure period, but in the event of a breach, for instance, there just may not be a cure that is possible if that information has been submitted to unauthorized disclosure. And then finally, there's a private consumer right of action in the event of a data breach. So that means that a consumer can sue you directly as a company and can recover between $100 to $750 per consumer per incident, or actual damages, whichever is greater. So if the consumer can show that they suffered actual damages, then that number could be even higher. And then also injunctive relief, which means that they could, depending on the nature of the violation, could require you to take action or stop taking action somewhere in the collection of data or your use of data. Enforcement begins on July 1st, but I do want to note that it was recently clarified that those enforcement actions could be for non-compliances that happened between January and July. Some of the recent updates and one of sort of the more controversial issues surrounding the CCPA and how companies are expected to comply with it. I just want to touch really quickly on the nature of a sale under the CCPA. So there are certain requirements that come into play when a company is determined to have sold personal information, and the definition that the CCPA has of sale is very broad and could be interpreted in ways that are sort of beyond our standard definition of the word sale. So any exchange of information, so if you, for instance, provide personal information to a marketing or advertising affiliate, and they use that personal information for their own purposes. So for instance, if they use it to augment their data profiles of consumers and existing data profiles that they have, then that could be considered a sale of personal information, even if you didn't directly receive sort of additional compensation for that purpose. So you're seeing a lot of what is required is a link that says do not sell my personal information on pages, and companies are really trying to figure out how do we explain this nuance of, we're not selling your personal information, but it may be considered a sale under the CCPA definition. So there have been some clarifications around what is considered a sale. So what you must do in order to comply with the CCPA, again, create a data map, understand where you're receiving data, with whom you're sharing it, how you're using it, update your privacy policy. As I said, there is a requirement to add a do not sell my personal information page to your website if you are selling personal information. Implement processes to verify and respond to consumer requests. So I noted all of those consumer rights, which include the right to request access and the right to request deletion of information. So you do need to have a process in place to verify that the consumer is the consumer in question, and to respond to those requests and ultimately to act on them in a timely manner, within 45 days, I believe, is the time frame. You need to train your employees. So once you implement all of these processes, you do need to train your employees, especially, for instance, customer service may need to be aware, and then your engineers may need to be aware based on different requirements around website changes and such. And then finally, again, consider any impacts to contracts. You may need to add additional addendums to your contracts with your vendors. You may need to add a requirement, for instance, that your vendor not use personal information for any other purpose than what the services they are providing to you, in order to avoid sort of the concept of a sale of personal information. Okay, the New York Shield. So next up is the state of New York. The New York Shield, which is the Stop Hacks and Improve Electronic Data Security Act. They were really reaching for that anagram there. So that went into effect, or goes into effect, on March 21st of 2020, although the data breach notification requirements went into effect in October of last year. It's very different from the CCPA. It really doesn't touch the CCPA in many areas at all. So the CCPA is very much focused on consumer rights and providing control to the consumer in their data. The New York Shield is much narrower in scope and is focused much more on the protection of certain fields of personal information. In many ways, it mirrors the HIPAA language in requiring companies to implement and maintain reasonable administrative, technical, and physical safeguards to protect personal information. But the definition of private information, or the term that they use here is private information, is much more narrow than we see in HIPAA or in the CCPA. So it is a very specific set of fields, including social security number, driver's license or state ID card number, account number or credit card number when it's paired with a password or a code that allows access to that account, biometric information, which would be fingerprints, voice prints, retina scans, etc., usernames or email addresses, together with a password or security question and answer that would permit access to that account. And then finally, the penalties for violating the New York Shield Act is a knowing or reckless violation could be a penalty up to $20 per violation. Again, each consumer record would be a separate violation, and if it's an ongoing violation, you could be looking at per consumer per day, with a maximum penalty of up to $250,000. Okay, what you must do. So I do want to point you first to a blog post here. We have a post up from this past summer that sort of addresses how to look at data privacy as a business problem, and it really comes down to three things, which is know your data and systems, know your responsibilities, and know your people. So that kind of comes down to, again, creating a data map, understanding what kind of data you're collecting and how you're using it and with whom you're sharing it, knowing what laws apply to your company, and then training and knowing sort of how it affects your employees and their day-to-day duties and operations. So reasonable safeguards, again, like the GDPR, the New York Shield does not really tell you what are reasonable safeguards for you, because it will vary very dramatically based on the company and the type of data that you are collecting and the resources that you have. So I've just provided a few different examples here of what would be considered technical safeguards, administrative safeguards, and physical safeguards. And these are just, this is just sort of skimming the surface of what these types of things could look like, but really you should be creating a comprehensive privacy program and putting in place different measures that really make sense and really address sort of the highest, most critical issues that you could come across in the type of data that you're collecting and how you're collecting it. All right, next up is Nevada. So Nevada kind of snuck in there. Everyone was looking at the CCPA, and then off to the side, Nevada was doing their own work, and they actually kind of snuck in, put in place a law in October 1st of 2019. The acronym here is not very elegant: Privacy of Information Collected on the Internet from Consumers Act. So here it's referring to covered businesses, or applies to covered businesses who are website operators or online service providers that collect and maintain information from Nevada residents and purposefully direct activities toward Nevada. Again, I recommend talking to an attorney about your specific facts to understand what it means to purposefully direct your activities towards the state of Nevada. So PII is sort of the general idea here of what kinds of information that they are looking at and what kind of information is covered under this law: name, address, email, phone number, social security number, or other personally identifiable information. So I kind of go with the idea of what information could reasonably identify an individual. What you have to do here, you must provide notice to consumers of what information you're collecting. This is really just an update to your privacy policy on what information that you're collecting and who you share it with. Provide consumers with a process by which they can review and request changes to their data, and provide an opt-out mechanism for the sale of personal information, even if you do not presently sell any personal information. So the CCPA "do not sell my personal information" link would also satisfy this requirement. Even if you don't believe that you meet the definition of sale, you do still have to do this here. Penalties, so injunctions or civil penalties up to $5,000 per violation. So again, could be a per record per day violation there. The numbers can add up quickly. So I won't go through this again because I just said all of those things, but there's what you must do in order to comply with Nevada. Now, if you are complying with California, save for the opt-out of sale of personal information if you don't sell, then you will likely be also in compliance with Nevada in a lot of ways. Okay, now that we've finished with the acts that have already gone into place, we're going to look at the Washington Privacy Act, which is legislation that is currently in process. So it is not in place yet, it's not final yet, so don't act on any of this as yet, but we're right now just monitoring and keeping tabs on what is happening here. So in its current form, the Washington Privacy Act would be effective on July 31st of 2021. It would cover entities that conduct business in Washington or produce products or services targeted to Washington residents. So if you meet that test, it applies if you process data of at least 100,000 consumers or derive at least 50% of your gross revenue from the sale of personal data, and process or control personal data of at least 25,000 consumers. Covered information is defined very broadly in this law as any information that is linked or reasonably linkable to an identified or identifiable natural person. I'm not sure if I mentioned earlier in the definitions of sort of PII or personal information that this typically excludes de-identified information, publicly available information, aggregated statistical data, things like that that can't be used to identify a person. So by encrypting data, for instance, you would be much less likely to experience a breach if the data was encrypted and could not be decrypted, for instance, with the information that was breached. The Washington Privacy Act, similar to both the GDPR and the CCPA, does provide rights to the consumer to access their data, correct incorrect data, and delete data, as well as the ability to port data to the consumer in a way that is usable, and to opt out of the collection or sale of information under certain circumstances. Now, there are limitations to this. So just as a for instance, this is true with the CCPA, and I would expect to see something similar under the Washington Privacy Act. If you have a loyalty program, for instance, and the consumer wants to participate in a loyalty program, then they can't opt out of your collecting certain information required in order to continue on that loyalty program. So there are going to be some limitations there to those consumer rights. So the Washington Privacy Act has been referred to as the most comprehensive state privacy legislation that's been proposed to date. And so it's really making waves as potentially a framework for a federal privacy legislation if we were able to ever get that done. Some of the highlights of the Washington Privacy Act include it does not require a "do not sell my personal information" page. What it does say is that it has to have an opt-out that is clear and conspicuous. It does require data protection assessments. This is the concept that we don't really see in the CCPA, but it does mirror the GDPR requirement for a data protection impact assessment. opt-in consent. So I do want to highlight the difference between an opt-out and an opt-in. So an opt-out means that you can collect it as long as the person, as long as and until an individual opts out of that collection. In this case, opt-in consent, meaning you cannot collect it unless an individual opts in, is required to process sensitive personal data, which would include the classification under a protected class, collection of genetic or biometric information. So again, that sort of retina scan, fingerprint scan, personal data from a child, someone who you know is a child, or specific geolocation data, and there is sort of a specific definition there, and will to be determined if that definition stays the same as this legislation is continues to be developed and revised. Similar to the GDPR, which again we don't see in the CCPA, is data minimization and the specification of the purpose of the collection of the information, and reasonable security measures that need to be put in place to protect information. So we see a lot of similarities here to the GDPR, so it's sort of a best of both worlds is really what they're going for. Penalties here are $7,500 per violation. There is no consumer private right of action as yet. So this is just the current state that the law is in. All of this could change. What if I suspect or have a data breach? Now I mentioned before that all 50 states have a data breach notification law, so I do want to touch really quickly on the concept of a breach and what happens if you suspect that information has been breached or your system has been breached in some way. So first, again, let's get on the same page with language here. What is a data breach? Every state's law is going to say something slightly different, but the general idea is it's any improper or unauthorized access or disclosure of personal information. What is not a data breach? Access or disclosure of information that's not included in the definition of personal information. So for instance, if IP address alone is being collected and it's not being stored alongside other information that could be used to identify an individual, the IP address may not be considered personal information under certain frameworks. Similarly, aggregated or statistical information. So if you take personal information and you create statistics based off of that, or you aggregate it into sort of more general numbers and it can't be used to identify an individual, or if that information is encrypted and has not been decrypted, that would not be considered personal information. So like I said, these definitions and requirements around data breaches and the notification requirements are going to vary based on which laws apply. So for instance, if you operate solely in Washington and you only ever collect information on individuals in the state of Washington, you'll only need to worry about Washington's data breach notification law. If you collect information on individuals in all 50 states, then yes, you are going to need to understand what your requirements and definitions are in all 50 states. As a caution here, I mentioned this before, that contracts may impose additional requirements or different definitions. So for instance, many data breach notification laws require that you notify individuals of a breach within 30, 45, 60, 90 days of becoming aware of a breach. But a contract could say that you have to notify your vendor or your client within 5 days of becoming aware of a breach, or 3 days, or whatever that number is. So you could have a shortened notification period, or it could cover additional information that is not just personal information. For instance, Microsoft might require you to notify them of a breach of any Microsoft confidential information. So what do I do if I suspect that I have a data breach? Well, ideally, you would have taken some action before this ever happened. You would create an incident response plan so that you are planning for what happens if this occurs. In this day and age, data is never 100% secure, and you've probably seen that in a number of privacy policies, that we cannot possibly guarantee that your information is going to be 100% secure, because that's just not how technology works. So we need to plan for what happens if and when you suspect a breach. If you do suspect a breach, then your first step is going to be to gather your incident response team. This needs to happen very, very quickly. Immediately upon understanding that there could possibly be a breach, you gather your team of key individuals. This might include, for instance, your president, your chief technology officer or other senior technology engineers that are familiar with the specific technology at issue. It might include your chief operating officer, your head of marketing, or someone on your marketing team. And ultimately, it should also include an attorney. An attorney will provide you with attorney-client privilege as long as you meet sort of the requirements of attorney-client privilege, which is that you are using them and talking to them to seek legal advice. Now, what you want to be careful of here is attorneys can act in different roles. So attorneys may be appointed as compliance officers or acting in some other business-focused role. And so you want to be really careful that your attorney is acting in their role as an attorney and that they're not wearing other hats alongside that when you are sort of going through this process. You want to mitigate the issue as quickly as possible, stop the breach, stop the issue as quickly as you can, and if possible, determine sort of how it occurred. And then you need to determine if a breach actually occurred. So you may have had an issue of, maybe an email went out, but that shouldn't have gone out, but actually it didn't include any personal information. So you may just need to kind of do some assessment there, investigate the scope of the breach. So did it include personal information? If so, whose personal information? How many individuals are we talking about? You want to understand then, and this all sort of would likely be happening concurrently. You would be kind of going through some of these steps all at the same time or simultaneously, determining which laws govern the information once you do understand what exactly has been compromised, if anything. And then once the dust has settled, send the required notifications. And like I said, if you have any contractual requirements there, you do want to understand what those look like and perform any required follow-up actions. So for instance, a data breach notification law and some of those follow-up actions may look like, if credit card information was breached, you might provide credit monitoring as a remedy. After a suspected breach, you are going to want to conduct a post-mortem assessment. What happened and why? How do we close any security gaps or any gaps in our operations? And did we respond well? And how can we respond better? Throughout all of this, you want to be very sure to document everything that you've learned and everything that you are doing and every action that you're taking in the response process, because these things happen so quickly and you just don't want anything to get lost there. And that documentation could very well help you. Again, it should be done under the attorney-client privilege so that it can maintain privileged if needed. Okay, what should I do now? So we've gone through all of these different laws. We've talked about what happens in the event of a breach. What do I do now? So while most people associate data security with technical measures like encryption and strong passwords, in reality, your employees are going to be often your first line of defense, and it's going to be a big part of the process of implementing sort of a comprehensive privacy program. So first, you want to understand and determine which laws apply to your company and the data that you are collecting and processing. You do want to create a data map and understand sort of what data you're collecting and how you're using it, where it's moving around in your systems. Finally, you're going to perform a risk assessment and you're going to address privacy and compliance as well as security. That risk assessment is really going to highlight where are our gaps, what are our requirements, and then where are our gaps in those requirements and how do we close those gaps. So again, I'm going to point you to our blog, which does speak on this a little bit more in depth. And if you do sort of want some additional guidance here, I always recommend speaking with an attorney. This can all be done under attorney-client privilege. Even if you are working with sort of a cybersecurity expert or some other consulting firm, if you involve an attorney, then this can all be done under attorney-client privilege. So I do want to highlight that having a well-trained and well-prepared team can be the difference between preventing a breach and responding to one. So you do want to make sure that your employees are informed every step of the way and really understand what this means for them and their role in sort of the everyday, day-to-day work that they're doing. Okay, so that was fast and furious, and we have covered everything that I've got here for you today for data privacy. I do want to highlight our next focus event, which is in March, on March 19th, which is Not Your Father's Performance Reviews. It'll happen at the same time from 9 to 10 a.m. here on the webinar. You can go to our website, equinoxbusinesslaw.com/event-directory to register for that event. And if you do have any questions, you can contact me at ashley@equinoxbusinesslaw.com. It has been a pleasure being with you guys this morning, and we look forward to helping you do your data privacy reviews and answering any other questions. If you're not familiar with our firm, we do a lot more than just data privacy. We also do work on employment, contracts, and really anything that you might need related to your business. Come and talk to me, and we will be following up shortly after the webinar with the recording and the slides, and we can also respond to any questions. And if we do get a number of questions, then we may also send out an FAQ after this webinar as well. Have a wonderful day. Cheers.